All right. This evening, we're going to be reviewing the Negotiable Instruments Act of 1881 Interpretation Clause. In this act, unless there is anything repugnant in the subject or context, A. Accommodation party means a person who has signed a negotiable instrument as a maker, drawer, acceptor, or endorser without receiving the value thereof, and for the purpose of lending his name to some other person. So, in most instances, when you sign a negotiable instrument, a promissory note, a bill of exchange, or a check, and you sign it with a blank endorsement, you become the accommodation party. And when you don't rebut or rebuke the fact that you are the accommodation party, you owe the debt. All right. B. Banker means a person transacting the business of accepting for the purpose of lending or investment or of deposits of money from the public, repayable on demand or otherwise, and withdrawable by check, draft, order, or otherwise, and includes any post office savings bank. C. Bearer means a person who, by negotiation, comes into possession of a negotiable instrument which is payable to bearer. That would be bearer paper. D. Delivery means transfer of possession, actual or constructive, from one person to another. E. Issue means the first delivery of a promissory note, bill of exchange, or check, complete in form, to a person who takes it as a holder. F. Material alteration. In relation to a promissory note, bill of exchange, or check, includes any alteration of the date, the sum payable, the time of payment, the place of payment, and where any such instrument has been accepted generally, the addition of a place of payment without the acceptor's assent. And G. Notary public includes any person appointed by the government to perform the function of notary public under this act, and a notary appointed under the Negotiable Ordinance 1961. Chapter 2 of Notes, Bills, and Checks. Again, this is about the 1881 Negotiable Instrument Act, ladies and gentlemen, and not too many people talk about it, which is a damn shame, because that's what we do every day throughout our life, is we negotiate instruments unbeknownst to us. Chapter 2, Notes, Bills, and Checks. Promissory notes. 4. A promissory note is an instrument in writing, not being a bank note or a currency note, containing an unconditional undertaking signed by the maker to pay on demand or at a fixed or determinable future time a certain sum of money only to, or to the order of, a certain person or to the bearer of the instrument. Illustration. A. Signs instrument in the following terms. A. Promises to pay B or order Taka 500. B. I acknowledge myself to be indebted to B in Taka 1000 to be paid on demand for value received. Mr. B, I owe you Taka 1000. And D. I promise to pay B Taka 500 and all other sums which shall be due to him. E. I promise to pay B Taka 500, first deducting thereout any money which he may owe me. F. I promise to pay B Taka 500 7 days after my marriage with C. G. I promise to pay B Taka 500 on D's death, provided D leaves me enough to pay that sum. H. I promise to pay B Taka 500 and to deliver to him May Black Horse on 1st January next. The instrument respectively marked A and B are promissory notes. The instrument respectively marked C, D, E, F, G, and H are not promissory notes. So let's go back and review A and B, as A and B are promissory notes. I promise to pay B or order Taka 500 I acknowledge myself to be indebted to B in TACA 1000 to be paid on demand for value received. So A and B are promissory notes. C, D, E, F, G, and H are not. Bill of Exchange. 5. Bill of Exchange. A bill of exchange is an instrument in writing containing an unconditional order signed by the maker directing a certain person to pay on demand or at fixed or determinable future time a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. A promise or order to pay is not conditional within the meaning of this section and section 4 by reasons of the time for payment of the amount or any installment thereof being expressed to be on the lapse of a certain period after the occurrence of a specified event which, according to the ordinary expectation of mankind, is certain to happen, although the time of its happening may be uncertain. The sum payable may be certain within the meaning of this section and section 4, although it includes future interest or is payable at an indicated rate of exchange or is payable at the current rate of exchange, and although it is to be paid in stated installments and contains a provision that on default of payment of one or more installments or interest, the whole of the unpaid balance shall become due. Where the person intended can reasonably be ascertained from the promissory note or the bill of exchange, he is a certain person within the meaning of this section and section 4, although he is misnamed or designated by description only. An order to pay out of a particular fund is not unconditional within the meaning of this section, but an unqualified order to pay coupled with an indication of a particular fund out of which the drawee is to reimburse himself, or a particular account to be debited to the amount, or B, a statement of the transaction which gives rise to the note or bill is unconditional. Where the payee is a fictitious or non-existing person, the bill of exchange may be treated as payable to bearer. 6. Check. A check is a bill of exchange drawn on a specific banker and not expressed to be payable otherwise than on demand. Drawer, drawee, drawee in case. The maker of a bill of exchange or check is called the drawer. The person thereby directed to pay is called the drawee. Of need, acceptor, acceptor for honor, payee. When in the bill or in any endorsement thereon, the name of any person is given in addition to the drawee to be restored to in the case of need, such person is called a drawee in case of need. After the drawee of a bill has signed his assent upon the bill, given his consent, or if there are more parts thereof than one, upon one of such parts, and delivered the same, or given notice of such signing to the holder or to some person on his behalf, he is called the acceptor. When a bill of exchange has been noted or protested for non-acceptance or for better security, and any person accepts in supra protest for honor of the drawer or of any one of the endorsers, such person is called an acceptor for honor. Acceptor for honor. The person named in the instrument to whom or to whose order the money is by the instrument directed to be paid is called the payee. Holder, payee. Number 8. The holder of a promissory note, bill of exchange, or check means the payee or endorsee who is in possession of it or the bearer thereof, but does not include a beneficial owner claiming through a benemandor holder. Explanation. Where the note, bill, or check is lost and not found again or is destroyed, the person in possession of it or the bearer thereof at the time of such loss or destruction shall be deemed to continue to be its holder. Holder in due course. 9. Holder in due course means any person who for consideration becomes the possessor of a promissory note, bill of exchange, or check, if payable to bearer, or the payee or endorsee thereof, if payable to order before it became overdue without notice that the title of the person from whom he derived his own title was defective. Holder in due course. Explanation. For the purpose of the section, the title of a person to a promissory note, bill of exchange, or check is defective when he is not entitled to receive the amount due thereon by reason of the provisions of Section 58, which we will get to later. Payment in due course. 10. Payment in due course means payment in accordance with the apparent tenor of the instrument in good faith and without negligence to any person in possession thereof under circumstances which do not afford a reasonable ground for believing that he is not entitled to receive payment of the amount therein mentioned. Inland instrument. 11. A promissory note, bill of exchange, or check drawn or made in Bangladesh and made payable in or drawn upon any person resident in Bangladesh shall be deemed to be an inland instrument. Foreign instrument. 12. Any such instrument not so drawn, made, or made payable shall be deemed to be a foreign instrument. Negotiable instrument. A negotiable instrument means a promissory note, bill of exchange, or check payable either to order or to bearer. Explanation. I. A promissory note, bill of exchange, or check is payable to order which is expressed to be so payable or which is expressed to be payable to a particular person and does not contain words prohibiting transfer or indicating an intention that it shall not be transferred. Explanation 2. A promissory note, bill of exchange, or check is payable to bearer which is expressed to be so payable or on which the only or last endorsement is an endorsement in blank. Explanation 3. Where a promissory note, bill of exchange, or check, either originally or by endorsement, is expressed to be payable to the order of a specified person and not to him or his order, it is nevertheless payable to him or his order at his option. Number 2, a negotiable instrument may be made payable to two or more payees jointly, or it may be made payable in the alternative to one of two or one or some of several payees. Negotiation. When a promissory note, bill of exchange, or check is transferred to any person so as to constitute that person the holder thereof, the instrument is said to be negotiated. Endorsement. When the maker of or a holder of a negotiable instrument signs the same otherwise than as such maker for the purpose of negotiation on the back or face thereof, or on a slip of paper annexed thereto, or allonged thereto, or so signs for the same purpose a stamped paper intended to be completed as a negotiable instrument, he is said to endorse the same and is called the endorser. Endorsement in blank and in full endorsee. This is very important. If the endorser signs his name only, the endorsement is said to be in blank, and if he adds a direction to pay the amount mentioned in the instrument to or to the order of a specified person, the endorsement is said to be in full, and the person so specified is called the endorsee of the instrument. 2. The provisions of this act relating to a payee shall apply with the necessary modifications to an endorsee. Ambiguous instrument. Where an instrument may be construed either as a promissory note or a bill of exchange, the holder may, at his election, treat it as either, and the instrument shall be forward treated accordingly. Where amount is stated differently in figures and words. 18. If the amount undertaken or order to be paid is stated differently in figures and in words, the amount stated in words shall be the amount undertaken or order to be paid. That's so important, ladies and gentlemen, because so often they say they give you a numeric value of what's due and owing, but they never put it in words, okay? And numbers really don't say anything at all. They're symbols. So when we're going to communicate, it's best that we express it numerically and alphabetically in order to substantiate what exactly we're speaking of. All right. And that's number 18 in the Negotiable Instruments Act of 1881. And I just felt it was important to make this video because not a lot of people talk about this. They say after 1933 in America that none of this stuff applies. And although they're talking about the negotiable instrument, we were visiting the Negotiable Instruments Act of 1881 out of India and Bangladesh, it still applies internationally because it was internationally accepted, okay, through the laws of nations, international banking. All right. Provided that if the words are ambiguous or uncertain, the amount may be ascertained by referring to the figures. Instrument payable on demand. A promissory note or bill of exchange is payable on demand. A, where it is expressed to be so, or to be payable at sight or on presentment, or B, where no time for payment is specified in it, or C, where the note or bill accepted or endorsed after it is overdue as regards the person accepting or endorsing it. Inchoate stamped instruments, where one person, number 20.1, where one person signs and delivers to another a paper stamped in accordance with the law relating to stamp duty chargeable on negotiable instrument, either wholly blank or having written thereon an incomplete negotiable instrument in order that it may be made or completed into a negotiable instrument, he thereby gives prima facie authority to the person who receives that paper to make or complete it, as the case may be, into a negotiable instrument for the amount, if any, specified therein, or where no amount is specified for any amount not exceeding in either case the amount covered by the stamp. 2. The person so signing shall subject to the provisions of subsection 3 be liable upon such instrument in the capacity in which he signed the same to any holder in due course for the amount specified in the instrument or filed upon up therein, provided that no person other than a holder in due course shall receive from the person so signing the paper anything in excess of the amount intended by him to be paid thereunder. 3. In order that any such instrument may, on completion, be enforceable against any person who became a party thereto, before such completion it must be filled up within a reasonable time and strictly in accordance with the authority given, provided that if any such instrument after completion is negotiated to a holder in due course, it shall be valid and effectual for all purposes in his hands, and he may enforce it as if it had been filled up within a reasonable time and strictly in accordance with the authority given. At sight, on presentment, after sight. Number 21. The expression after sight means in a promissory note after presentment for sight, and in a bill of exchange after acceptance or noting for non-acceptance or protest for non-acceptance, when note or bill payable on demand is due. 421A. A promissory note or a bill of exchange payable on demand shall be deemed to be overdue when it appears on the face of it to have been in circulation for an unreasonable length of time. A note or bill payable at a determinable future time. 21B. A promissory note or bill of exchange is payable at a determinable future time within the meaning of this act if it is expressed to be payable. A. At a fixed time after date or sight, or B. On or at a fixed time after the occurrence of a specified event which is certain to happen, though the time of its happening may be uncertain. Antedating and post-dating. 21C. A promissory note, bill of exchange, or check is not invalid by reason only that it is antedated or post-dated, provided that antedating or post-dating does not involve any legal or fraudulent purposes or transactions. Days of grace. The maturity of a promissory note or a bill of exchange is the date at which it falls due. Every promissory note or bill of exchange which is not expressed to be payable on demand, at sight, or on presentment is at a maturity on the third day after the day on which it is expressed to be payable. Calculating maturity of bills or note payable so many months after date of or sight. In calculating the date at which a promissory note or a bill of exchange made payable a stated number of months after date or after sight or after a certain event is at maturity, the period stated shall be held to terminate on the day of the month which corresponds with the day on which the instrument is dated or presented for acceptance or sight, or noted for non-acceptance, or protested for non-acceptance, or the event happens, or where the instrument is a bill of exchange made payable a stated number of months after sight and has been accepted for honor, with the day on which it was so accepted. If the month in which the period would terminate has no corresponding day, the period shall be held to terminate on the last day of such month. Illustration A. A negotiable instrument dated 29th of January 1878 is made payable at 1 month after date. The instrument is at maturity on the third day after the 28th of February 1878. B. Negotiable instrument dated 30th August 1878 is made payable 3 months after date. The instrument is at maturity on the 3rd December 1878. And C. The promissory note or bill of exchange dated 31st August 1878 is made payable 3 months after date. The instrument is at maturity on the 3rd of December 1878. Calculating maturity of bill or note payable so many days after date or sight. In calculating the date at which promissory note or bill of exchange made payable a certain number of days after date or after sight or after a certain event is at maturity, the day of the date or of presentment for acceptance or sight or of protest for non-acceptance or on which the event happens shall be excluded. When day of maturity is a holiday. When the day on which a promissory note or bill of exchange is at maturity is a public holiday, the instrument shall be deemed to be due on the next preceding business day. Explanation: the expression public holiday includes Sundays and the days declared by the government by notification in the official gazette to be public holidays. Chapter 3. Parties to notes, bills, and checks. Capacity to make, etc., promissory notes, etc. 26. Every person capable of contracting according to the law to which he is subject may bind himself and be bound by the making, drawing, acceptance, endorsement, delivery, and negotiation of a promissory note, bill of exchange, or check. Minor. Where such an instrument is made, drawn, or negotiated by a minor, the making, drawing, or negotiation entitles the holder to receive payment of such instrument and to enforce it against any party thereto other than the minor. Nothing herein contained shall be deemed to empower a corporation to make, endorse, or accept such instruments except in cases in which, under the law for the time being in force, they are so empowered. Agency. This one's important. Number 27. Every person capable of binding himself or of being bound by the making, drawing, acceptance, or negotiation of a negotiable instrument may so bind himself or be bound by a duly authorized agent acting in his name. When you go to a car lot, the agency working at the car lot is actually your agent, ladies and gentlemen. And they're kind of bamboozling you. Not kinda, they are. They're fist fucking you 6 ways from Sunday. And I kinda gotta watch my language because YouTube will ban me too. So, a general authority to transact business and to receive and discharge debts does not confer upon an agent the power of accepting or endorsing bills of exchange so as to bind his principal. An authority to draw bills of exchange does not of itself import an authority to endorse. Authority of partners. 27A. A partner acting in the firm name may bind the firm by the making, drawing, acceptance, or negotiation of a negotiable instrument to the extent authorized by law relating to partnership for the time being in force. Liability of agent signing. 28. Where a person signs a promissory note, bill of exchange, or check without adding to his signature words indicating that he signs it as an agent for and on behalf of a principal or in a representative character, he is personally liable thereon, but the mere addition to his signature of words describing him as an agent or as filing as a representative character does not exempt him from personal liability. 2. Notwithstanding anything contained in subsection 1, any person signing a promissory note, bill of exchange, or check for and on behalf of the principal is not liable to a person who induces him to sign upon the belief that the principal alone would be held liable. Transferor by delivery and transferee. This is so important, and when I was looking for people that have done videos on negotiable instruments, you don't see too many of them that are done in English. Most of them are done by people from India and other countries, and this is so important, ladies and gentlemen, that you understand that the Negotiable Instruments Act of 1881 is upon us, and it has been upon us since 1882, which is actually when it was enacted and adopted by everybody. Transfer by delivery and transferee. Where the holder of a negotiable instrument payable to bearer negotiates it by delivery without endorsing it, he is called a transferor by delivery. 2. A transfer by delivery is not liable on the instrument. 3. A transfer by delivery who negotiates a negotiable instrument thereby warrants to his immediate transferee, being a holder for consideration that the instrument is what it purports to be, that he has a right to transfer it, and that at the time of transfer, he is not aware of any defects which renders it valueless. Liabilities of legal representative signing. A legal representative of a deceased person who signs his name to a promissory note, bill of exchange, or check is liable personally thereon unless he expressly limits his liability to the extent of the assets received by him as such. Signature essential to liability. No person is liable as maker, drawer, endorser, or acceptor of a promissory note, bill of exchange, or check who has not signed it as such, provided that where a person signs any such instrument in a trade or assumed name, he is liable thereon as if he had signed it in his own name. Forged or unauthorized signatures. Subject to the provisions of this act, where a signature on a promissory note, bill of exchange, or check is forged or placed thereon without the authority of the person whose signature it purports to be, the forged or unauthorized signature is wholly inoperative, and no right to retain the instrument or to give a discharge therefore, or to enforce payment thereof against any party thereto can be acquired through or under that signature, unless the party against whom it is sought to retain or enforce payment of the instrument is precluded from setting up the forgery or want of authority, provided that nothing in this section shall affect the ratification of an unauthorized signature not amounting to a forgery. Stranger signing instrument presumed to be endorser. A person placing his signature upon a negotiable instrument otherwise than as maker, drawer, or acceptor is presumed to be an endorser unless he clearly indicates by appropriate words his intention to be bound in some other capacity. Liability of drawer. The drawer of a bill of exchange, by drawing it, engages that on due presentment it shall be accepted and paid according to its tenor, and that if it be dishonored, he will compensate the holder of any endorser who is compelled to pay it, and B. The drawer of the check, by drawing it, engages that in the case of dishonor by the drawee, he will compensate the holder, provided that the due notice of dishonor of the bill or check has been given to or received by the drawer as hereinafter provided. 2. The drawee of a bill of exchange is not liable thereon until acceptance in the manner provided by this act. Liability of the drawee of a check. The drawee of a check, having sufficient funds of the drawer his hands properly applicable to the payment of such check must pay the check when duly required so to do, and in default of such payment must compensate the drawer for any loss or damages caused by such default. Liability of maker of a note and acceptor of bill. 32. In the absence of the contract to the contrary, the maker of the promissory note by making it, and the acceptor before maturity of a bill of exchange by accepting it, engages that he will pay it according to the tenor of the note or his acceptance respectively. And in the default of such payment, such maker or acceptor is bound to compensate any party to the note or bill or any loss or damage sustained by him and caused by such default. 2. The acceptor of a bill of exchange at or after maturity by accepting it engages to pay the amount thereof to the holder on demand. Only drawee can be acceptor except in need of for honor. No person except the drawee of a bill of exchange or all or some of several drawees or a person named therein as a drawee in case of need or an acceptor for honor can bind himself by an acceptance. Acceptance by several drawees, not partners. Where there are several drawees of a bill of exchange who are not partners, each of them can accept it for himself, but none of them can accept it for another without his authority. Liability of endorser. In the absence of a contract to the contrary, the endorser of a negotiable instrument by endorsing it engages that on due presentment it shall be accepted and paid according to its tenor, and that if it be dishonored, he will compensate the holder of the subsequent endorser who is compelled to pay it for any loss or damage caused to him by such dishonor. Every endorser after dishonor is liable as upon an instrument payable on demand. Liability of prior parties to holder in due course. Every prior party to a negotiable instrument is liable thereon to a holder in due course until the instrument is duly satisfied. Maker, drawer, and acceptor or principal. The maker of a promissory note or a check, the drawer of a bill of exchange until acceptance, and the acceptor are, in the absence of a contract to the contrary, respectively liable thereon as principal debtors, and the other parties thereto are liable thereon as sureties for the maker, drawer, or acceptor, as the case may be. Prior party, a principal in. As between the parties so liable as sureties, each prior party is, in the absence of a contract to the contrary, also liable thereon as a principal debtor in respect of each subsequent party. That's respective each subsequent party illustration. A drawer of a bill payable to his own order on B who accepts, A afterwards endorses the bill to C, C to D, and D to E as between E and B. B is the principal debtor, and A, C, and D are his sureties as between E and A. A is the principal debtor, and C and D are his sureties between E and C. C is the principal debtor, and D is his surety. Liability of accommodation party and position of accommodation party. 38A. An accommodation party is liable on a negotiable instrument to a holder in due course, notwithstanding that when such holder took the instrument, he knew such party to be an accommodation party. 2. An accommodation party to a negotiable instrument, if he has paid the amount thereof, is entitled to recover such amount from the party accommodated. Suretyship. When the holder of an accepted bill of exchange enters into a contract with the acceptor, which, under Section 134 and 135 of the Contract Act 1872, would discharge the other parties, the holder may expressly reserve his right to charge the other parties, and in such case, they are not discharged. Discharge of endorser's liability. When the holder of a negotiable instrument, without the consent of the endorser, destroys or impairs the endorser's remedy against a prior party, the endorser is discharged from liability to the holder to the same extent as if the instrument had been paid at maturity. Illustration. A is the holder of a bill of exchange made payable to the order of B, which contains the following endorsement in blank. First endorsement B. Second endorsement Peter Williams. Third endorsement Wright and Co. Fourth endorsement John Raziaro. This bill puts in suit against John Razio and strike out without John Razio's consent the endorsement by Peter Williams and Wright and Co. A is not entitled to recover anything from John Razio. Acceptor bound, although endorsement forged. An acceptor of a bill of exchange already endorsed is not relieved from liability by reason that such endorsement is forged if he knew or had reason to believe the endorsement to be forged when he accepted the bill. Acceptance of bill drawn in fictitious name. An acceptor of a bill of exchange drawn in a fictitious name and payable to the drawer's order is not, by reason that such name is fictitious, relieved from liability to any holder in due course claiming under the endorsement by the same hand as the drawer's signature and purporting to be made by the drawer. Negotiable instruments made, etc., without consideration. A negotiable instrument made, drawn, accepted, endorsed, or transferred without consideration, or for a consideration which fails, creates no obligation of payment between the parties to the transaction. But if any such party has transferred the instrument with or without endorsement to a holder for consideration, such holder and every subsequent holder deriving title from him may recover the amount due on such instrument from the transferor for consideration or any prior party thereto. Exception. No party for whose accommodation a negotiable instrument has been made, drawn, accepted, or endorsed can, if he have paid the amount thereof, recover thereon such amount from any person who became a party to such instrument for his accommodation. Exception 2. Excuse me there. No party to the instrument who has induced any other party to make, draw, accept, endorse, or transfer the same to him for a consideration which he has failed to pay or perform in full shall recover thereon an amount exceeding the value of the consideration, if any, which he has actually paid or performed. Partial absence or failure of money consideration. When the consideration for which a person signed a promissory note, bill of exchange, or check consisted of money and was originally absent in part or has subsequently failed in part, the sum which a holder standing in immediate relation with such signer is entitled to receive from him is proportionally reduced. Explanation. The drawer of a bill of exchange stands in immediate relation with the acceptor. The maker of the promissory note, bill of exchange, or check stands in immediate relation with the payee, and the endorser with his endorsee. Other signers may by agreement stand in the immediate relation with a holder. Illustration. A drawer of a bill, A draws a bill on B for taka 500 payable to the order of A. B accepts the bill, but subsequently dishonors it by non-payment. A sues B on the bill. B proves that it was accepted for value as to taka 400 and as an accommodation to the plaintiff as to the residue. A can only recover taka 400. Partial failure of consideration not consisting of money. Where a part of the consideration for which a person signed a promissory note, bill of exchange, or check, though not consisting of money, is ascertainable in money without collateral inquiry, and there has been a failure of that part, the sum which a holder standing in immediate relation with such signer is entitled to receive from him proportionally reduced. Holder's rights to duplicate of lost bill. This is important as well. Hold on, I gotta blow my nose here. All right. Where a bill of exchange has been lost before it is overdue, the person who was the holder of it may apply to the drawer to give him another bill of the same tenor, giving security to the drawer if required to indemnify him against all persons, whatever in case the bill alleged to have been lost shall be found again. If the drawer on request of aforesaid refuses to give such duplicate bill, he may be compelled to do so. Of negotiation, delivery. 46. The making, acceptance, or endorsement of a promissory note, bill of exchange, or check is completed by delivery, actual or constructive. As between parties standing in immediate relation, delivery to be effectual must be made by the party making, accepting, or endorsing the instrument, or by a person authorized by him in that behalf, as between such parties and any holder of an instrument other than a holder in due course. It may be shown that the instrument was delivered conditionally or for a special purpose only, and not for the purpose of transferring absolutely the property therein. A promissory note, bill of exchange, or check payable to bearer is negotiable by the delivery thereof. A promissory note, bill of exchange, and check payable to order is negotiable by the holder by endorsement and delivery thereof. Negotiation by delivery. 47. Subject to the provisions of Section 58, a promissory note, bill of exchange, or check payable to the bearer is negotiable by delivery thereof. Exception. A promissory note, bill of exchange, check delivered on condition that it is not to take effect except in certain events is not negotiable except in the hands of a holder for value without notice of the condition unless such event happens. Illustration. A. The holder of a negotiable instrument payable to a bearer delivers it to B's agent to keep for B. The instrument has been negotiated. B. The holder of a negotiable instrument payable to bearer, which is in the hands of A's bank, who is at the time the banker of B, directs the banker to transfer the instrument to B's credit in the banker's account with B. The banker does so and accordingly now possesses the instrument as B's agent. The instrument has been negotiated and B has become the holder of it. Negotiation by endorsement. 48. Subject to the provisions of Section 58, a promissory note, bill of exchange, or check payable to order is negotiable by the holder by endorsement and delivery thereof. Conversion of the endorsement in blank into endorsement in full. When a negotiable instrument has been endorsed in blank, any holder may, without signing his own name, convert the blank endorsement into an endorsement in full by writing above the endorser's signature a direction to pay the amount to or to the order of himself or some other person, and the holder does not thereby incur the responsibility of an endorser. Effect of endorsement. 50. Subject to the provisions of the Act relating to restrictive, conditional, and qualified endorsements, the endorsement of a negotiable instrument followed by delivery transferred to the endorsee the property therein with the right of further negotiation. 2. An endorsement is restrictive, which either A, restricts or excludes the rights to further negotiate the instrument, or B, constitutes the endorsee an agent of the endorser to endorse the instrument or to receive its contents for the endorser or for some other specified person, provided that the mere absence of the words implying right to negotiate does not make the instrument restrictive. Illustration. B signs the following endorsement on different negotiable instruments payable to bearer. A. Pay the contents to C only. B. Pay C for my use. C. Pay C or order the amount of B, and D. The within must be certified to C. These endorsements exclude the right of further negotiation by C. E. Pay C. F. Pay C value in account with the Oriental Bank, and G. Pay the contents to C, being part of the consideration in a certain deed of assignment executed by C to the endorser and others. These endorsements do not exclude the right of further negotiation by C. Who may negotiate? Every sole maker, drawer, payee, or endorsee, or all of several joint makers, drawers, payees, or endorsees of a negotiable instrument may, if the negotiability of such instrument has not been restricted or excluded as mentioned in Section 50, endorse and negotiate the same. Explanation. Nothing in the section enables a maker or a drawer to endorse or negotiate an instrument unless he is in lawful possession or is a holder thereof, or enables a payee or endorsee to endorse or negotiate an instrument unless he is a holder thereof. Illustration. A bill is drawn payable to A or order a endorser, an endorser's A endorses it to B. The endorsement not containing the words or order or any equivalent words, B may negotiate the instrument. Endorser who excludes his own liability or makes it conditional. The endorser of a negotiable instrument may, by express words in the endorsement, exclude his own liability thereon, or make such liability or the right of the endorsee to receive the amount due thereon depend upon the happening of a specified event, although such event may never happen. Where an endorser so excludes his liability and afterwards becomes the holder of the instrument, all intermediate endorsers are liable to him. Where the right of an endorsee to receive the amount due on the negotiable instrument is made dependent in the aforesaid manner, the condition is valid only as between the endorser and the endorsee. Where the endorsement of a negotiable instrument purports to be conditional, the payer may disregard the condition, and payment to the endorsee is valid whether the condition has been fulfilled or not. Illustration. A. The endorser of a negotiable instrument signs his name, adding the words "without recourse." Upon this endorsement, he incurs no liability. B. A is the payee and the holder of the negotiable instrument. Excluding personal liability by an endorsement without recourse, he transfers the instrument to B, and B endorses it to C, who endorses it to A. A is not only reinstated in his former rights, but has the right of an endorsee against B and C. Holder claiming through holder in due course. 53. A holder who delivers his title through a holder in due course, and who is not himself a party of any fraud or illegality affecting the negotiable instrument, has all the rights therein of the holder in due course as regards the acceptor and all parties to the instrument prior to the holder. Where the title of the holder is defective, if he negotiates the instrument to a holder in due course, that holder obtains a good and complete title to the instrument, and B, if he obtains payment of the instrument, the person who pays him in due course gets a valid discharge for the instrument. Rights of holders in due course. 53A. A holder in due course holds the negotiable instrument free from any defect of title of prior parties and free from defense available to prior parties among themselves, and may enforce payment of the instrument for the full amount thereof against all parties liable thereon. Instrument endorsed in blank. Subject to the provisions hereafter contained as to crossed checks and negotiable instruments endorsed in blank, is payable to the bearer thereof, even although originally payable to order. Conversion of endorsements in blank into endorsements in full. If a negotiable instrument, after having been endorsed in blank, is endorsed in full, the amount of it cannot be claimed from the endorser in full except by the person to whom it has been endorsed in full, or by one who derives title through such person. Requisites of endorsement. Negotiation by endorsement must be of the entire instrument. An endorsement which purports to transfer to the endorsee only a part of the amount payable, or which purports to transfer the endorsement to two or more endorsees severally, is not valid as a negotiation of the instrument. But where such amount has been paid in part, a note that effect may be endorsed on the instrument, which may then be endorsed for the balance. Legal representative cannot, by delivery, only negotiate instruments endorsed by deceased. The legal representative of a deceased person cannot negotiate by delivery only a promissory note, bill of exchange, or check payable to the order and endorsed by the deceased but not delivered. Negotiation of instrument of party already liable thereon. Where a negotiable instrument is negotiated back before maturity to the maker or drawer or a prior endorser or to the acceptor, such party may, subject to the provisions of this act, reissue and further negotiate the instrument, but he is not entitled to enforce payment of the instrument against any intervening party to whom he was previously liable. Right of a holder. A holder may receive payment in due course under a negotiable instrument and further negotiated in the manner provided by this act. He may also sue on such instrument in his own name. Defective title. When a promissory note, bill of exchange, or check has been lost or has been obtained from any maker, drawer, acceptor, or holder thereof by means of any offense or fraud, or for an unlawful consideration, neither the person who finds or so obtains the instrument nor any possessor or endorsee who claims through such person is entitled to receive the amount due thereon from such maker, drawer, acceptor, or holder, unless such possessor or endorsee is or some person through whom he claims was a holder thereof in due course. Instrument acquired after dishonor or when overdue. The holder of a negotiable instrument who has acquired it after dishonor, whether by non-acceptance or non-payment with notice thereof, or after maturity, has only, as against the other parties, the rights thereon of his transferor, and is subject to the equities to which the transferor was subject at the time of acquisition by such holder. Accommodation note or bill. Provided that any person who, in good faith and for consideration, becomes the holder after maturity of a promissory note or bill of exchange made, drawn, or accepted without consideration for the purpose of enabling some party thereto to raise money thereon, may recover the amount of the note or bill from any prior party. Illustration. The acceptor of a bill of exchange, when he accepts it, deposited with the drawer certain goods as a collateral security for the payment of the bill, with power to the drawer to sell the goods and apply the proceeds in discharge of the bill if it were not paid at maturity. The bill not having been paid at maturity, the drawer sold the goods and retained the proceeds, but endorsed the bill to A. A's title is subject to the same objection as the drawer's title. Instrument negotiable till payment or satisfaction. The negotiable instrument may be negotiated except by the maker, drawee, or acceptor after maturity until payment or satisfaction thereof by the maker, drawee, or accept, or at or after maturity, but not after such payment or satisfaction. Chapter 5. Presentment. When we come back, we're going to be talking about presentment. Nobody's talking about the Negotiable Instruments Act of 1881, accepted in 1882. It's really important to understand this because this ties into the UCC when you're dealing with negotiable instruments. Understand that all obligations are obligations of the United States, and if you're an American, you have a birth certificate that proves that you have special drawing rights, and that all of your instruments are in fact security obligations of the United States. Thank you for joining me. When we come back, we'll start out with Chapter 5 and we'll move on to presentments, all right? This is a super important topic that everybody must become familiar with. Thanks for joining me, and we'll see you soon.